Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call, which we do every other Thursday. Everybody is welcome to join. As our disclaimers when you log in tell you, we are not forming an attorney-client relationship. As best as we can, we try to guide our people. But this is not a formal retention or advice. That said, there are a few people logging in now. Just to repeat, I think everybody can hear me. I've double checked it a few times. But if you cannot, my Twitter window is open, immigration.com. You can tweet to me, immigration.com without the dot. So immigration.com, but no dot, immigration.com. All right, folks, I'm off-site today, so typically that can cause some hiccups here and there because I don't have my office set up. Let me just double check before we keep going. So testing 1, 2, 3.
The conference is now in conversation mode.
When I said testing 1, 2, 3, everybody could hear me, right?
Yes. Yes, Raj.
Beautiful.
Yes, Raju.
Beautiful. I'm not taking any chances. Okay.
The conference is now in presentation mode.
Let's get started on our questions. The first one is from Arjun, who says, I've received my re-entry permit. Folks, I didn't get a chance to review all the questions today, so I'm going to have to go a little slower. I'm reading them now. Getting married to a bride from India, visiting India in December. I know what the process is. She's 33, works for an Indian-German auto company. So basically, he was trying to figure out how to minimize the separation between his wife and him once they get married. And the problem, Arjun, is this. When anybody applies for a tourist visa, there is a question on the forms that says, does your fiancé live in the USA? And there is no real definition of a fiancé. It's anybody you want to get married to or you intend to get married to. So therefore, whether she applies before marriage, you are a fiancé. After marriage, you are her husband. This fact will come out, and if it does not come out, I think government can haul you up for committing fraud. Be careful with this. Okay? Because you could really mess up your case. First part. Second part of the problem is, once she lands at the airport, Customs and Border Protection will ask her, why are you coming? If she says she's coming for tourism, that's a lie because she's coming to meet her husband. That's the primary reason. So therefore, that could be fraud as well. There really is no easy way to do this. Whether you do it before marriage, after marriage, how would you respond at the airport? Now, I'll also tell you this. We've got clients who were in this situation. They got married, and after marriage, went and applied for a tourist visa saying, look, we're going to be apart for a long time. It would be nice if she can come for a 6 months period and then she can go back. She will not violate her status. And surprisingly, some of them really actually did procure a tourist visa with complete truth. I have actually a client I talked with today who had a very interesting case. He's got his green card. The family moved to India. They lost their green card. But then after being in India, they wanted to come back. And as a green card holder, if he applied for them, it would take them a couple of years to come in. So we actually sent them back to the consulate for a visa, explained the whole situation, told the consulate, look, the kids have to go to school and we would rather have them go to school here. There's no point in them waiting outside USA. He's already here. Consulate actually gave them all a tourist visa. So they are here and we've been extending their tourist visa every 6 months, actually stay every 6 months. So this can be done. My inclination always is to tell the truth and not conceal anything. Okay? I don't think that your planning is a good idea. You should go the simple route, apply for her green card, You can go to India, but be careful with that as well. If you're gone too long, you can lose your green card. And obviously, you can also have a problem with your naturalization. If she is qualified for a H1 visa, L1 visa, that would be a great option, because those visas are indifferent to any green card going. Arjun, if you are here, press *5. Press *5 if you have a question for me. Press *5 on your phone. Okay, I guess you're not here. We'll keep going to the next question then. Next question is from Jane S.J. I-140 in EB3 filed in Jan 2017 in Texas. The case has been received at the local office. Do you think the case is taking too long? Who can submit the inquiry? Well, first of all, I'm not quite sure why the case was transferred to the local office. At the I-140 stage, that I'm not sure is usual. Of course, our team members who deal with the logistics would know better. But as far as I know, there are only two reasons why a case is transferred to the local office, either for interview or for investigation. A little bit further along the line, I'll be talking about adjustment of status. I took a quick look at the questions that we had for today, but I didn't get a chance to read them all in detail. As we go down, I'll talk about the adjustment of status. So I'm not sure why your I-140 was transferred. That doesn't, either it's work redistribution or investigation. So I'm not sure which case falls in your, under which category your case falls. Okay. So as far as generically the issue of who can submit a case inquiry in the form I-140, it's your employer or your lawyer. I doubt very much that the government will talk with you. I want to add a comment here. Previously, it used to be that in I-140s, the employees could not even respond to a notice of intent to revoke. But Administrative Appeals Office has been going in the other direction more recently. They've started saying, well, employees have a right to have some say in these cases. I don't remember the details of the case, but it was a recent case just in the last few months. Nevertheless, as far as the frontline USCIS is concerned, I would be surprised if they talk with you about the I-140. So your lawyer who represents the employer or the employer can call. Remember also that even your supervisor can call. Somebody who represents the employer can call. *5 if you have a follow-up question. *5. Okay. Let's go on to the next question then. This is from Mahendra S. My employer started my green card some time back. LCA was denied. You mean POM was denied. LCA is for the H1. Because there were some errors, employer started working on green card process for the third time. I applied for national interest waiver. It got approved. The third attempt by my employer worked and I-140 got approved. I advised the employer's attorney to apply for H1B extension using NIW I-140, but the attorney decided to apply for H1B extension using employer's I-140. My question is, if I don't use NIW I-140, will it expire? No, it will not. An I-140, once approved, stays good forever. That's the current rule. An I-140, whether under NIW or EB1A or EB2 or EB3, once approved, it is good forever. No question there. *5, if anyone has a follow-up question on this, *5. *5. Okay. Let's go on to the next question then. So here is a situation. What happened? Okay. Here's a situation where H1B amendment was approved without the I-94 attached. Okay. So What that means is when you get an H1B approval but you don't get an I-94, that means government considers you to be out of status. There is some violation of your status. Now, there is a delicate interplay between these concepts: out of status, unlawful presence, authorized period of stay. These are concepts that are closely related and can be quite tricky. So I wouldn't want you to make decisions by yourself. I would rather have you talk with your lawyers in detail what your next step should be. But generally speaking, when you don't get an I-94, you are out of status and you are present illegally in the United States. Whether or not you're unlawfully present is another question. Why is it important? Because unlawful presence of 180 days equals 3 years bar from entering the United States. Unlawful presence of 1 year equals 10 years bar. So it is important to know whether you are just out of status or also unlawfully present. Now, in October, you started working. They put you in a location more than 1,000 miles different from location A. This is a little complicated. Let me try to see if I can figure this out. You transferred your H1B, Prakash, from employer A to employer B. During the transfer, employer B filed LCA for location A. Let's call it location X. When H1B transfer was approved, they put me to work in location Y, okay, which is more than 1,000 miles. Employer B forgot to file LCA for location Y. Okay. Then when they realized their mistake, so you've been out of status the moment you started working at location Y, for which you were not approved. Now, that's not unlawful presence. In your case, unlawful presence would be when your I-94 expires. In your case, that's what I'm seeing, but please confirm with your lawyers since it is such an important decision. But you already left USA in Feb 2017, went to British Virgin Islands, and then they filed H1B amendment, they sent the receipt. I entered USA with this receipt notice. You see, because I think you were already in violation of your status. That's why the government didn't give you status, but it looks like you don't have any problem with the unlawful presence, but you are required to go and get visa stamping. That's what it looks like to me, what I can see. So let's look at your questions. What does this mean? I just explained. Am I out of status? Yes. Should I go outside, get passport stamped? Yes. Star 5 if you have a follow-up question on this. Star 5. Star 5 if you have a follow-up question. Okay. Doesn't look like you do. Let's go on to the next question. This one is from Rick. Rick says, I have 2 questions. This question should have been asked multiple times earlier, but I'm here asking it again. Looking for an employer who can file my cap subject H1 during April, waiting until October for it to be, okay. How can we do it differently other than looking for, okay. My current employer is a large non-profit. Well, there are 2 different questions, I'm sorry, okay. So the first one again is there any news or ways we can do it differently other than looking for an employer who can file my cap subject H1 during April? Well, you know that you can do a concurrent H1. So if you have, this is a very weird law, but if you are on a cap-exempt H1, let's say you are working for a government research organization, NIH, let's say, and you got their cap-exempt H1. Now, IBM offers you a job. IBM is a for-profit corporation. Technically, you can't work for them until they take you through the quota system. However, there is a weird interpretation of the law according to which if you want to do 2 jobs simultaneously and you have an H1 through a cap-exempt employer, you can get a concurrent H1 without a quota issue for the for-profit employer. So because you're working for NIH, you can do a concurrent H1 for IBM even though you have not gone through the quota system. So concurrent H1 is the only way around this. There's another way, which is sometimes the job can be quota exempt even though the employer is not quota exempt. So once again, let's take an example that you are working for IBM Corporation, or you are being offered a job from IBM Corporation, and the job is to support NIH. Because NIH is a quota exempt organization and your job is to support NIH, your job becomes quota exempt. That's an interesting thing. A lot of times people don't realize that even though the employer is not quota exempt, the job can be quota exempt because you're supporting the function of a quota exempt organization. Okay, I trust that is clear. If you're here, I can always answer follow-up questions, or anybody has any follow-up questions. And the second part was, if we file for a green card and somebody qualified shows up, do they have to let you go and hire the new person? Of course not. Look, this is a very odd, strange process, but the idea behind PERM is to test the labor market. You're not looking to hire people, but you're looking to test the labor market. And in many ways, employers find that very distasteful. It almost sounds like we are committing some kind of a wrong act upon the US workers because we don't intend to hire them, we just want to test if they are out there. Well, that's the scheme Congress has set up. We are testing the labor market. If somebody qualified shows up, there is no law that says that the employer has to let you go and hire them. They just can't go forward with the green card process. They'll have to try again. Star 5, if anyone has a follow-up question on any of these issues. Star 5. Okay, let's go on to the next question. This one is from Ram Shankar. I'm here on a J1 visa working as a special education teacher. Can I move to another employer in USA and transfer my visa? J1 visas have certain rules, like all other visas. But J1 visas, the rule is, if you are working for the agency that issued your 2019, so if your school issued your 2019, of course you can't change employers. You'll have to get another 2019 from another organization. But sometimes what happens is you have some kind of a master organization, for example, American Association for Practical Training, and you've come under their J1 visa. They issued the 2019 and they placed you at this school. If they have another school they can place you at, they might be able to get that done for you. So it all depends upon your situation. It's a good idea to talk with your program officer, the person who is responsible for your J1, the J1 officer. Speak with them and see what options you have. Star 5, if you have a follow-up question on this, Star 5. Press Star 5 on your phone. Okay, doesn't look like we have any follow-up questions today. All right, let's keep going. Anon many nines. So Anon 9999 says, now you see, this is a case where somebody was, I can only guess, they were very young. They had a green card, but they never came back after leaving. Now here's what happens. I hope you're on the phone. I can tell you generically what the law is. Let's say I have my green card and my child is 14-year-old. With the whole family left and went to India or Switzerland, wherever we are from, and we are out there for a couple of years. Now after a year the green card is gone. The child may want to come back, but the fact is that the whole family moved. Therefore, the child has lost the green card even though they were just a minor. It was always their intention to keep their green card, but that can't help them. The intent and the departure of the family is fully their responsibility as well, even though they were not a part of that decision. So the fact that you have an active social security number does not mean that you can get your green card back. I don't see how you can get your green card back. *5 if you have a follow-up question on this. *5. So once you're outside USA for 1 year, your green card is already gone. Okay. Doesn't look like we have a follow-up question. I'm getting some doubts. Let me just double check everybody can hear me.
The conference is now in conversation mode.
Just under check, guys. Can you all hear me okay? Everybody can hear me fine?
Yep. Yeah, Rajiv.
Yeah.
Okay.
Yes, Rajiv.
Good. Excellent. Thank you.
The conference is now in presentation mode.
Yeah, last week something odd happened. Oh, somebody has a hand up. Something odd happened. People couldn't hear me and I didn't know that. So, okay. Rhode Island, go ahead, please. You have a follow-up question? Rhode Island?
Yeah. So, quick question here. This is regarding to my question. So, the expiry date is not there on the card as well.
That doesn't matter. Let me interrupt you for a second. The expiration on the
Okay.
green card, expiration date on the green card has really very little meaning. Okay.
Okay.
Just because even if you had an unexpired green card that said you're good till 2020, but you were gone from 2015 through 2017, your green card is gone, even though the expiration date is not until 3 years down the line.
Mm-hmm.
Okay. Because green card is tied to your actual stay in the United States and your intention to stay in the United States, not just the expiration date.
Quick, I think, case here. So I have two things in front of me. One, I know someone who just had the similar case and, they got it renewed through a formal process.
Okay.
Like they went to an attorney
Let
and
me
got it.
also interrupt you for 1 second. Understand how this process works. The agency that does the green card renewals treats the green card renewal as a purely administrative matter. So for them, receiving the old card with the request to renew the card, that's all they need to see. They don't go beyond that. They don't go into the facts of the case. If this person were to ever apply for, let's say...
Okay, I found something on the web for the old card question. That's all they need to see. They don't go beyond...
1 second. These stupid voice-activated devices.
Sorry.
Okay. Didn't even ask the device anything. Anyhow, so going back to what I was saying, if they were to apply for naturalization, or if somebody were to look into their case in greater detail, without a question, their green card will be taken away. Without a question. So not getting caught and having a successful green card are two different things. Don't confuse the two. The reason they got away with this is because the last time they entered USA, nobody checked. They were able to pass through. When they applied for extension of the green card, that's just an administrative process. Nobody really looks into the details of your status. Okay.
Right.
Make sense?
Yeah, I think the one I was mentioning actually went to a formal attorney and got it reinstated. But thank you for nonetheless telling me on your case as well.
Right, but you're welcome to, of course, talk with any number of lawyers. Immigration law is a very complex field. There may be somebody who knows something I don't. I doubt it very much, but you can ask. Okay.
Thank you.
You're welcome. Good luck. Yeah, these laws and these procedures can be so complicated. Okay, let's go on to the next question. This one is from Arsha24. I was on H1B until 2015 with an approved I-140 since 2014. Huh? Approved I-140. Oh, okay. So I-140 was approved in 2014. I-140 has not been revoked. I had one month left on my H1B when my change of status to H4 and H4EAD were approved. My I-140 was filed by a previous employer in a different field. Can I use the same H1B? First of all, there is no requirement that your H1B extension must be applied in the same field in which the original H1 was. That is no problem at all. You completed MBA and you want to extend your H1, you can. So you can use your I-140 to... Okay, yeah, you can use your I-140 for extension. Shah, I don't see any problem with it. It is definitely an option available to you. Star 5 if you have a follow-up question on this. Star 5. Star 5 if you have a follow-up question on this. Okay, let's go on to the next question. This one is from G. Gunn. Says, job change from employer to employer B 3 years ago. Employer A to employer B 3 years ago. B filed green card under EB2. I-140 was approved last May. I'm planning to change the job from B to C. If employer C has to file my green card and requires the experience letter that has all the detailed description of my role with employer B doesn't provide me the letter, can they still file my green card under EB2? Oh yeah, absolutely. Because look, if you can quantify and prove bachelor's degree plus 5 years of post-bachelor's experience or master's degree with whatever experience that is being required, either one of those cases gets you an EB2, and it is not necessary that you quantify and prove your entire experience history. So if there is an employer, even though it's the most recent employer, doesn't want to give you the letter, that does not mean you can't get an EB2. Another question. My employer B has filed my green card with a role as software programmer. If my new green card is under senior development engineer, will that be any concern? No, not at all. Even if you went from a programmer to a system administrator or a network engineer or any such quality assurance engineer, I don't think that's a problem. Each new green card is a new case. It can be for any job for which you can qualify. Star 5 if you have a follow-up question. Star 5. Okay, let's take that question. This one is from Washington State. Go ahead, please, Washington State. Hello, Washington State.
Oh, hi. Hi, Rajiv. So I have a question to my first question there. You mentioned I can, like my employer C can file the GC and the EB2 category.
Right.
And I mentioned the employer B cannot.
Can I interrupt you for just one moment?
Yeah, sure, definitely.
Do you have a US master's degree or are you going under bachelor's plus 5?
I have a bachelor degree from India.
Okay. And I'm assuming you have one of those technology degrees, 4-year degree, right? After 12th standard?
Yeah, correct. So that is equivalent to US degree. So I have the equivalent certificate also.
Very good. And now,
the second thing,
let me get some information from you.
Sure,
when did you finish your degree?
2007.
Okay. Now, all you have to do is you have to document 5 years of experience, gradually more responsible experience from 2007. Whether you do 2007 to 2012 and stop there, or you do 2009 to 2014 and stop there, or you do 2010 to 2014 and then 2015 to 2016. It doesn't matter how you prove the 5 years. There's no requirement that you have to prove 5 years continuous.
Okay. Yeah. So that's why I mentioned, I mentioned in the first scenario that I changed my employer A to B 3 years ago. So I have that total 6 years experience with employer A, and I have the experience letter from them too. So is that good enough evidence for the next
Yes,
GC processing?
yes, absolutely. But just make sure that the letter shows that you did progressively more responsible jobs for them. So if you were hired as
Yeah.
a systems trainee, then you became a programmer, then you became a programmer analyst, then you became an architect, something like that. That shows progression in your career.
Yeah, yeah, because the same experience letter was used for filing my first green card,
No,
like with
don't
employer
rely
B.
upon
Same
that
experience there.
as being as sufficient, because every case is a new case. That which was acceptable
Okay.
yesterday may not be acceptable today. Just have your lawyers review it, make
Mhm.
sure that the letter meets the requirements for EB2. And
Okay.
I don't see any
Okay.
problem with just having one letter from employer A. And if you got nothing from employer B, so be it. By the way, you can also prove employer B's experience through secondary methods. But I'm not making it too complicated. I'm just telling you that employer A itself is sufficient, but your lawyer should be able
Mhm.
to help you to prove even employer B's, even though they are not giving you a letter. Okay.
Okay. Okay. And I have one more question. Can I ask you,
Of
or
course. Go ahead.
shall I just hold off
No,
some?
no, that's
Yeah.
fine.
So, yeah, I mentioned about that I will be changing my job. So my employer C has recently filed the LCA, and they are planning to file the H1B like in this week.
Okay.
So my question is regarding the same line, like there has been a recent change in the H1B, like whether it be transfer or any change, like there will be more scrutiny. Like recently means I think like it was changed in October 23rd. So what would be the impact? Like what is the scrutiny that they are going to add for any H1B extension or transfer or anything? Do you have any idea on that line?
There is absolutely no change in practice. If you go to my Facebook page, I have discussed this with one of the community members. I think some Mr. Singh, who was very concerned. And I told him that what I'm telling you now is that these are just semantics. We're going to give more scrutiny, less scrutiny. They were doing the same thing. They've been doing the same thing for 8 years. Every time you file a case, whether it is a new case, an amendment, a change of companies, a transfer, extension, they always scrutinize the case from the very beginning. Nothing new here. Some of the reporting in Indian newspapers that I have seen is horrible. It's incorrect. Don't think that newspapers, even though Trump says false media and all that nonsense, the fact of the matter is that newspapers can get it wrong sometime, and they have it wrong. This is not a big deal. This has always been the case. Always will be the case.
Okay. Thank you, Rajiv. I will have all the follow-up question later on,
No
like
problem.
once we
Good
end
luck
up
to you.
all the. Yeah.
Sure.
Thank you.
You're welcome, sir. Okay. So now let's go on to. Oh, I like that picture. Okay. This is from Ilagnamus. I don't know how to say that. Green card holders since 2004, eligible to apply for citizenship since 2009, got married to an Indian citizen, decided to apply, extensive international travel last 5 years, predominantly driven by business needs of my employer, was always away for less than 6 months. Last 5 years travel schedule showed 950 plus days outside, violates the 30-month rule. Question. Being told I can't claim any exemption, must file N400 into some of the trips. Yes, that is true. There is really, you can't really do much. There is a form called N470 that can sometimes protect you if you are moving overseas for a longer period of time. But there is no provision for somebody who travels very, very frequently, even though it is for the purposes of a US employer. So you're going to have to do the 30-month physical presence. I don't know personally of any way around that. If there is some, I would have to research it, although I doubt very much that there is a way around that. Star 5, if you have a follow-up question on this, star 5. Okay. Next question is deep impact. Yeah, this is the gentleman who's. These are two people who said in this call they couldn't hear me talk last time, and that's why I was surprised because I invited questions and nobody had any questions. I was very surprised. Either the community has become very well educated, or maybe I was not clear. I didn't realize my voice was not coming through. So this time I've made sure. I've talked with you folks a couple of times, made sure that I'm coming through. So. No problem, Deep. I'm sorry that happened the last time. I was not in the office. I'm not today. Also, I'm not in the office. So sometimes when my setup is changed, it can happen. Things like that can happen. I try not to have them, but they can creep up. So I'm on L1A, and your 7 years are getting over. Wife is on H1B, going to India, coming back in December 15. On December 15th. We are planning to request my wife's employer to file my change of status along with H4EAD with future date before my L1A maxes out. Yeah, that seems okay. We are going to India for vacation. We'll be back. When you come back on 15th, you're still on L1A, so there's no problem. When you come back, you're going to ask for an H4, future H4, along with an EAD. I think that's fine. Will it create any issues because just after getting L1A, I'm applying for change of status? I don't think so. I don't think that's a problem at all. If my company decides to send me back to India after my visa expiry, say in 15th Feb, but I've applied for change of status, can you stay? Yeah, you can stay here. I don't see any problem. You can, because your change of status is pending. You can stay here. There's a little bit of a unknown area here because you've asked for the kickoff date as April, but you have stopped working in Feb. Government can decline you change of status, and that could actually end up declining your EAD if they go really by the book. But can you stay here until they take some action against you? Yes. Typically, government doesn't ask for another proof of status once you file your L1, your H4 EAD and H4. But if they did ask and you were out of work at that point of time, they would decline your H4. They'll say, go out, get your visa stamping done and come back, and then apply for an EAD again. Can I come back from India with H1B stamping for a few days, apply H4 EAD here, and return back to India to serve my notice period? I think that's too complicated. It can be done, but you should really have a discussion with your lawyers on this. I hesitate to give you a snap decision. It is certainly a possibility. Okay, now one thing you got to realize, if you have an H1 to H4 or L1 to H4 change of status pending, you cannot leave USA. If you leave USA, your change of status request is abandoned. So your EAD is also gone. So if you travel when the H4 is still pending, that H4 vanishes, and so does the EAD. I will apply change of status from April 1st, but if USCA does not approve H4, can I continue to work with my present employer? Of course. Till your L1A is valid, you are still on L1A. Till your change of status is approved, you haven't moved over to H4. You're still on L1A. Okay. Deep, if you are here, press *5 if you have a follow-up question. *5 if you have a follow-up question. Okay. Texas, go ahead, please. Texas.
Yeah, Rajiv, Deep here. So, like, if I want to be a safer side, so once I come back from the India, say, in December 15, so I can ask my company's lawyer or my spouse lawyer to apply the change of status from the instead of April 1st, maybe from Feb 1st, right? And they will definitely take some time. And until they approve it, I can continue working with my employer with L1A.
That is correct, yes, sir. You can continue working with your employer until your change of status is approved.
Okay. So already you have answered, like, even if I apply for April 1st, they don't approve it. Do I apply for change of status April 1st? I can continue working till April 15 when my petition is pending.
Yeah, as long as, see, even though you asked for change of status effective April 1st, If they don't approve it on April 1st, they'll give you approval from the date they approve it. So if they approve it on April 17th, even though you asked for April 1st, they'll make it effective from April 17th. That's the normal rule.
Okay. So just for the example, like suppose I applied for say March 1st and they approved it. Okay. And in that case, and I can anyway I will have the EAD, so I can still continue working with my current employer. Instead of L1A, I will be on the H1 H4 EAD, right?
Deepji, the underlying assumption that you will get EAD at the same time as you get the H4 is incorrect. You may not, but if you did get an EAD and the change of status and the EAD approval came through, of course you can continue working for the L1A employer or any employer that you choose to work for.
Okay.
Okay. Are we done?
Yeah, I have questions I asked last time. Not so this is a good time to ask some small question, but I couldn't. Like last time, we have some technical problem in the call.
Okay. Do you have that question still, or are you done? If you have that, go ahead. Ask.
Yeah, small.
Yeah, go ahead.
Like so, for my daughter, the company applied for H4 conversion, L2 to H4. It's been 5 months and we don't have any status. Site is telling we received your petition on June 1st, but it's more than 5 months.
Yeah, I wouldn't worry.
And we are planning to go to India.
See, if you go,
but we are planning to go to India.
That's not a problem. Look, there are 2 things I want you to know. 3 actually. 1, timings government gives you are very uncertain. You never know. 2nd, when a child is under the age of 18, they can never accrue unlawful presence. Therefore, even if they are without status for 10 years, I don't care. Okay. When a child is under the age of 18. 3rd thing is, if you leave during the pendency of the H4 is deemed abandoned, but you can get H4 visa stamping and come back. Remember, for H4 visa stamping, approval from USCIS is not needed. So you could travel, just get her H4 visa stamp and you come back. Okay?
Yeah, last question. So while taking the visa interview date for my wife, so they are asking like receipt number and company who applied for 797 or receipt. My wife's company has been acquired by a different company, new company. So shall I write new company name because they have given one travel letter for USCIS? This company acquired by this company and all those things.
I cannot help you fill forms because when I help in that, I should also sign the form ethically. But I can tell you generically, when there is a acquisition of a company by another company, and the acquisition is a proper successor in interest, which is what the letter will say, then I think, generally speaking, that new employer is the employer. They have taken over the role of the old employer. And I think everywhere you should, from that point forward, mention the new employer.
Okay. Why I was thinking I generally go for visa Chennai. So Chennai, they write Chennai, in parentheses they write Madras. So I was thinking, can we have to put the new company in parentheses old company, or just I need to write the new company?
Once again, I can't help you fill forms, but I answered your question generically that once a company is taken over, the old company no longer exists.
Got it. Thank you so much.
Good luck, sir.
Thank you.
You're welcome. Then the next question is from JP 2017. And this question is currently on H1B visa. I-140 was approved in May this year for EB2. H1B extension has been approved. H1B visa expires Jan 2018. Now, this is about visa renewal process. According to the US Travel Docs website, I fit all the criteria for an interview waiver. Last time I didn't do it through the Dropbox. Dropbox option is only available in India. It's only available in the countries that are included in the Dropbox program. So it's country to country. It's not something you can say is only India. Whichever country has opted for that option, whichever the consulate has opted for that option. I've been told that currently they are interviewing almost everyone who's not had an interview within the past 12 months. I don't know what the rule in India at this point is, sir. Unfortunately, or fortunately, I am removed from many of the logistical problems. My team members take care of those. As to these tertiary issues, what fees to take, where to go, all these things somebody else in my office does. So I really don't know what the rules are there for everybody to see on their website. So you can just take a look at it. I don't have any idea. The chances of getting the Dropbox option again, I don't know. What risks if I to get renewal in Canada? I have had so many people go to Canada and I don't see any problem, none that I am aware of. In fact, just 3 days ago, one of our clients went in and he went to Ottawa and he had no issue at all. So I don't know how to answer that question. What risks implications? Other than getting stuck in Canada for a few days, and also you need a visa to enter Canada, a Canadian visa, I don't see any problem. Nothing new, JP. I can't think of anything else that you need to worry about. But I think your lawyer should review your case that we do in every H1B filing, just to make sure that you're fulfilling all the legal requirements. Other than that, I don't see any issue. Go for it. *5. Any follow-up question? Press *5. Okay. We'll go on to the next question. Oh, there is a question. All right. Again, Washington State. Go ahead.
Hi, Rajiv.
Yeah, Washington State.
Yeah, I just have a question here regarding the renewal of H1B in Canada. So does you need to have, like for example, if you are on in like internal project of the company and not the client, so do you need to be with the particular client to go for the visa stamping outside the country, or no, it's like even if the company can provide you the client letter, because there are many talk about this, like there should be a client that should provide you the client letter that you have.
You see, what the government is looking for is a genuine job. A genuine job. Let us take 2 examples. One example is where you are working with a company that provides consulting services to other companies. So there you have always got an end client because you're working for somebody at all times providing services, even though your employer is this company. That's one situation where you will need an end client letter. You must have an end client letter because you're working at somebody else's premises. One of the key distinguishing factors between an end client situation and no end client situation is when you're working from somebody else's premises. The second situation is, let's say the company is Microsoft. Microsoft produces its own software. They have their own software and that is the project. They have no end client. They don't need an end client. Let's take a third situation, which is a hybrid. Let's say you are in the Microsoft consulting group where they provide consultations on their own products. There, sometimes you might be working from a client side, but it's always a short-term project. So that means even there, the end client is really your own company. There's no end client. So it is not necessary to have an end client. In fact, many of the stronger H1s are when there is no end client and you're working directly for your own company. As long as the job is genuine, it can be proven to the satisfaction of the consulate. Make sense?
Yeah, thank you.
Yeah.
Thanks a lot.
Okay, let's go on to the next question. We just discussed this about the burden of proof, and I said, look guys, it is the same. There is nothing new. When you do an extension, it will be the same assessment that always has been. Now they've just said it in formal language, but last 7, 8, 9 years they've done the same thing. It has always been a new case. Nothing to worry about, nothing new. *5 if you have a follow-up question. *5. Okay. So Kibi is an F1 student doing MBA, second year, got 1 more year. I've received an offer from a UN agency in Europe to do some consultancy work where I'll be paid on the daily basis upon submission of deliverables. So basically, you're working for a foreign agency and delivering your work outside. The only thing is you are doing the work inside USA. I know of lawyers who have successfully argued that if there is no connection at all with the United States, the work can be performed within the USA. I am a little bit more conservative. I feel that any work done on the US soil could be potentially considered to be unauthorized employment. So in my view, it can violate your F1 visa status, but I know lawyers, and I know lawyers who have very successfully argued, although I think it's a little bit of a risky proposition, that if there is no connection between the work and the agency that's getting the work done and your work in the United States, no connection at all, and this is not a violation of your status. So you can take your pick. B, UN doesn't deduct income taxes due to tax treaties. Look, income is income. Okay, so you will be paying taxes as a 1099. I'm not a tax expert. You need to talk with the CPA on this. But in my understanding is, if you are a US resident, then, and as an F1 student, I think you are a US resident, but again, please talk with a CPA. My knowledge of tax laws is woefully inadequate. I don't know how it works. So I think you'll have to pay taxes. If you start your own online startup company, can I do that? The answer is again the same problem. This is even more complicated because there is a connection between USA. I think that will be a violation of your status. You can do it on OPT, CPT, no, but you can, well, I think on OPT you can do. Yes, of course. On OPT you can do this. I don't see any problem with that. At least for the first 1 year, that's for sure. Okay. Star 5 if you have a follow-up question. Star 5. Next question is IMI Help 84. I'm an H1B. Wife came to USA March 5th, 2015. Valid H4 visa until March 2018. I-94 is only good till March 5th, so 18 days less. Recently, we got H1 and H4 extension approval with valid I-94s from March 24th, 2018 to March 23rd. Now she has the gap of 19 days. So that is March 5th through March 24th. I think she's legal to stay, personally, because it's called a de minimis violation, such a small violation, it shouldn't matter. I personally think it's okay. Star 5 if you have a follow-up question. Okay, there's a follow-up question. Let's take that. New York, go ahead, New York. New York.
Hello, Raju. Thanks for the service.
Yes, sir.
So my question is there any problem when we are filing the GC? When we are filing the 485 with this gap?
No. Remember, under Immigration Nationality Act Section 245K, you are forgiven up to 180 days of out of status, up to 180 days, and each time you travel, your entire back slate is wiped off. So if you were to travel, even the 14 days are gone. So with the 14 days, you still have another 166 days that you can be out of status without any problem.
Okay. And one more thing, like she is on H4, she has H4 EAD and she is working full time. So in this gap, still she can work, right?
I wouldn't work during the gap, no.
Oh, okay. She has to take a break for those 20 days and again start working?
Yeah, I wouldn't I wouldn't work during those 14 days, no.
Oh, okay.
Right.
Because we got the H4 EAD, from October 2017 to whatever 21. So we have that H4 EAD legal status to work, but I'm not sure about this gap. That's why.
She's okay to stay, I think, but I don't think she's okay to work. I wouldn't do that.
Okay. Thanks, Raju. That's all I need. Thank you very much.
Good luck.
Thank you.
Okay. So another comment that they had a problem with the conference call last time. Luckily, there's nothing now. So we should be okay. Again, H1B renewal process, I already told you this is nothing new. Don't worry about it. Next question is Saeed Shahabuddin, who says, I applied for citizenship along with my wife, Feb 15, 2017. Biometrics are done. Received interview call. Took oath. She hasn't gotten her interview call. She's on the background check. You know what you can do, Said? You can talk with a local lawyer, because it's not possible for us. Wait, we can do it. Maybe easier to get it done locally. There is a limit to how far the government can delay your case. I think that is something like 4 months, 120 days. No, not 120, something like 4 months. The only problem is some courts, some circuits have said the date that 4-month period triggered off when the application is ripe for adjudication. In other words, that security period, as long as the security check is pending, the deadline is not triggered. Some other courts have said, no, you can't do that. So it's something that you can have your local lawyers take a look at and see if you can file a lawsuit against the government. Typically, I avoid these lawsuits because government behaves like little kids. When you sue them, they just tend to make things unnecessarily difficult. And under Trump, this is only likely to get worse. So until Trump is gone, we are dealing with some very strange times. Okay, so *5 if you have a follow-up question. So I would just wait if I were you. *5. Okay. Last question is, my H1B transfer got approved and after a month received RFE. Is premium processing handled by different officers? I don't know the answer to that question. I think it's handled by the same officers. That's my guess. I don't think it's different officers. But I'll have to check with our own team and people who deal with these sorts of issues. I don't know the answer definitively, but I think it's the same officers. *5 if you have a follow-up question. *5. Okay, we've got a follow-up question. Let's take that. And this one is also from Washington. Washington, go ahead, please. Washington. Okay.
Hello, hi Rajiv.
Oh, 1 second. One second. I'll unmute you. What happened? Can you press *5 again, please? Sorry. Press *5 again. Press *5. Okay. Go ahead, Washington. Go ahead.
Yeah, Rajiv. Just a question here. Like, I have seen the cases where people try to change to the employer and then they get RFE and they come back to the original, like a previous employer. So I'm currently going through the same scenario, like my new employer will be filing the H1B. So what should be the state of action if you receive the RFA? Should it be staying with the same employer or should it be changing to the old employer back? So what is your suggestion on that?
RFE is not a problem. I have never worried about RFEs. RFEs are a fact of life. And in fact, if I represent the employer, which we do in H1 cases, we never let an employer walk away from an RFE. It creates an implication that the employer is trying to run away from something. So unless there's a good reason, one should always respond to the RFE. Now, if you're an employee and you feel that the employer is not really doing a good job on the RFE, government has said that you can always go back to the old employer if they have not revoked the H1. Okay. But actually the employer is supposed to revoke. When you leave, they are required by law to revoke. However, if they have not revoked, you can go back and join them.
Okay. Can I ask you another question if you don't mind?
I guess it'll have to be the last question of the day. Go ahead, please.
Okay. So I just have a question. Like, I have read the article, different articles on the I-140. So my I-140 is approved like for more than a year, and I recently got my wife H4EAD. So like I will be changing a job. So there won't be any impact on her EAD or anything related to her. Am I right? H4.
As long as you're maintaining your H1, the fact that you are changing your employer 1 to 2 to 3 to 4 has no impact on the H4 or the H4EAD. Okay?
Okay. And she doesn't have to refile the H4 if she already got the extension from my previous, not the previous employer, but when we did my H1.
She does not have to.
Thank you.
You're welcome. Good luck. Okay, so I guess we have one more hand up. And let's see. We'll take this one. This one is from Texas. I guess we have, after that, one more hand up. Okay. All right, guys. I'll try to deal with that.
Yeah, Rajiv.
Yeah, go ahead, please. Texas.
Yeah, this from Deep from Texas. This is a follow-up question from the JP. So you were talking about the client letter, and many times clients say they don't give the letter. But in visa interview, we need to have some proof to what alternative we can take. Client is not willing to give the end client letter.
The problem is there are certain things that are very difficult to prove without the end client letter. This has become an excuse for the government to deny cases. There really is no solid reason why this should be a part of the requirements. There's a whole history behind this, and I think government is definitely open to a new challenge about this requirement of end client letters. Nevertheless, as a practical matter, as a practicing lawyer, all I can tell you is this. If you don't have an end client letter, you're going to have a lot of secondary evidence to prove what are the dates of the employment, how long is the project, what is the employer-employee relationship, what is the job description, job title. There's a bunch of things that have to be that have to come from the end client. It can be in the form of letter, it can be in the form of other documentation. What that other documentation is impossible for me to say. Many times the job order or the work order has information about some of the things that we need, but it's very rare to find secondary documentation that contain everything that the end client letter normally contains. Okay. So these are tough cases to win.
Yes. Somebody was telling like we can take the photo of the from the thing. We can take the photo or the chart of the company where you are reporting to manager on that company.
None of
that is
none of that.
Not still.
It's not reliable.
Okay.
It's not reliable.
Okay.
Good luck, sir.
Thank you.
You're welcome. Okay, and I guess we have two more. Oh, I thought we had one more, but I guess we have two more. So this one is from Pennsylvania. Pennsylvania, go ahead, please. Pennsylvania.
Hi Rajiv, good afternoon. Last question, you told like when any employer is revoking anybody's H1, do they need to pay any money to get it revoked, or is just any letter is fine?
Just a letter. They don't have to pay anything. There are three components in a valid H1 termination. Number one, the employer must tell you your job is over. Number two, they must offer you one-way ticket back to your home country if you want it. And number three, they must write to the USCIS to revoke the case. Okay?
Okay, so if any company is doing like that, will it create any negative history for that company?
You mean if they don't revoke?
If they revoke?
No, revocation does not create. Why should it create a negative history? It's your right. Company's right to revoke a case.
Okay, all right. Thank you, Rajiv.
You're welcome. Good luck. Okay, and I think we have one more. Or do we not? I can't tell.
Yes, Rajiv, this is Help 84.
Yes, sir, go ahead.
Sorry, I forgot to ask you this thing. So my wife has this 19 days gap, right, between the last I-94 and the current I-94.
Sure.
So is there a way she can go to the nearest CBP or USCIS office and get it corrected?
This was given by the USCIS. CBP cannot correct it as far as I know.
So recently we got the approval. Maybe I can we can call them and ask for the change to correct the change.
You can certainly try, but I don't think it can be done over the phone unless it's a government error. It doesn't hurt to ask. Let's put it this way. It doesn't hurt to ask.
Okay.
All right.
Okay. Because you are told she should not work in that gap,
No,
right?
she
So
shouldn't.
I don't know whether I don't know whether she has to take the leave or there is we have to stop the payroll also.
No, she can take. Look, unauthorized employment has two components. One is working, the other one is getting paid in cash or kind. So if you are missing any one of those components, then there is no problem. So if you are working but not getting paid in cash or kind, that's okay. Of course, there are other issues with that. There's something called Fair Labor Standards Act that doesn't allow that. But let's say from immigration perspective, if you are working but not getting paid, for a moment, let's assume that's okay. But if you are getting paid and not working, for example, if you take a leave of absence but you're still getting your benefits, that's okay because you're not working.
So that is still okay? I mean, she can take a leave and...
Absolutely. Perfectly fine.
Yeah, because she has some leaves left for her company, like 2 weeks or something. She can utilize that, right?
Absolutely no problem.
Okay. 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 Thank you, Rajiv.
You're welcome. Good luck, everyone. Oh, I have one more again. Okay.
Thank you very much.
Take care.
Appreciate it.
Bye-bye. Okay, we have one more. No problem. You guys have been waiting a long time. Okay. Let's see. This one is from New York. New York, go ahead.
Yes. Thank you for your comments. I'm the student with the offer from a UN agency in Europe. You mentioned something regarding connection, work connection. I'm not clear on this point. Can you please give an example? What do you mean by the connection?
I'm not sure I understand your question. Why don't you ask me your question again? I'll try to answer as best as I can.
Okay, so you mentioned that it would not be a violation of my F1 status if there is no connection.
Okay, got it. So you are asking about if I am in USA on student visa and I get an offer from a United Nations agency to do some work for them which has no connection with USA. Connection means this. For example, let us say, let's not take the case of United Nations. I think they always have a connection. I think United Nations will always have a connection with USA. But let's take the example of a private company. The private company is in Holland and they do import-export business with China. And they want you to work on their website. They have no business in USA. Okay. Now, this company in Holland, you're doing work for them, they have no connection with USA. They are not getting any raw material from USA. They're not exporting anything to USA. They don't have any staff in USA. They're not selling in USA. That's what I mean by connection.
Okay, so practically if the projects that I'm handling have nothing to do with clients in the US, then it should be okay.
Well, the thing is, I'm in a very uncharted territory here. The area that we are talking about, there really is no clear law laid out on this. My approach is, if you are in USA, don't work for anybody else. Okay. But there are lawyers I know who have said no. If there is no connection, which is what I just described to you, you can work even though you are in USA. You know what you can do? You can actually try contacting the USCIS. Contact the USCIS. It might take you all day to get through, but once you get through, explain to them the problem and say, I want to talk with somebody, an adjudications officer in USCIS. So they will then most probably the frontline staff will transfer you to a USCIS officer who can tell you what they think. Then whatever they say, this is important, write it down. Get the officer's number. They'll either give you their first name or their number. Date it, time it. Say on Thursday, November 15th, I spoke with Officer Janet, who told me this at this time. Now, if you do that, at least you have some defense against the government claiming that you've done unauthorized employment. This is not a perfect defense, but at least it is some defense. I feel it is the conservative thing to do is not to do this on American soil. If you do it from a third country, that's fine. But if you work from USA, I think government can question it. But you can check with them. Okay.
Okay. All right. Thank you so much, sir.
You're welcome.
Thank you.
Good luck. Okay, I think we are done for today. Guys, it's always a great delight to talk with all of you. In fact, somebody in our firm was mentioning that I'm spending so much time on conference calls. They were actually a little bit, I guess, concerned. And I said, look, this is something we've done for 2 decades. So I really like doing it, and I'm not going to stop doing this. But no worries. It's all good. This administration has created a lot of work for all of us. But this too shall pass. It won't stay like this forever. Talk with you again in 2 weeks, guys. Bye-bye.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.